Kentucky has a lightly regulated breaking lease framework with an important structural distinction. The state operates under a dual legal system where some counties have adopted the Uniform Residential Landlord and Tenant Act, while others rely on common law and older statutory provisions. The governing law includes the Kentucky URLTA, found in Kentucky Revised Statutes, Chapter 383, for counties that have adopted it, along with common law principles for non-URLTA counties and general contract law. If you're a landlord or tenant in Kentucky, which framework applies to your property significantly affects the breaking lease process. Let's start with the landlord's duty to mitigate damages. In URLTA counties, which include the major population centers like Louisville, Lexington, and other urban areas, the landlord has a statutory duty to mitigate. Under KRS 383.670, when a tenant abandons the property or breaks the lease, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot leave the unit vacant and collect the full remaining rent from the departing tenant. The landlord must take reasonable steps: advertising, showing the property, and accepting a qualified applicant. The departing tenant's liability is limited to rent during the vacancy period plus reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced. In non-URLTA counties, primarily rural areas and smaller communities that have not adopted the Act, the mitigation duty is based on common law principles. The common law duty to mitigate exists, but may be less clearly defined and less consistently enforced than the statutory duty in URLTA counties. Landlords in non-URLTA counties should still make reasonable re-rental efforts because courts generally recognize the mitigation principle even without a specific statute. But the legal framework is less detailed. This dual system creates a practical challenge for landlords who own properties across multiple Kentucky counties. A property in Louisville operates under URLTA with a clear statutory mitigation duty. A property in a rural county that hasn't adopted URLTA operates under common law with a less defined framework. Landlords should know which system governs each of their properties and adjust their procedures accordingly. Early termination clauses are generally enforceable in Kentucky, in both URLTA and non-URLTA counties. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months rent is typical and enforceable under general contract principles. The fee must represent a reasonable estimate of anticipated damages. An excessive penalty clause could be challenged. Kentucky courts generally enforce reasonable negotiated terms. In URLTA counties, the early termination clause must be consistent with the Act's provisions, including the mitigation duty. A clause that eliminates the mitigation duty or imposes the full remaining rent as liquidated damages without accounting for mitigation is more vulnerable to challenge in a URLTA county than in a non-URLTA county. Military members have the right to break a lease under the SCRA. Kentucky has a significant military population. Fort Campbell, straddling the Kentucky-Tennessee border, is home of the 101st Airborne Division and generates enormous rental demand in the Hopkinsville and Oak Grove areas on the Kentucky side. Fort Knox, south of Louisville, is home to the Army's Human Resources Command and generates military rental demand in Radcliffe, Elizabethtown, and Vine Grove. The Bluegrass Army Depot near Richmond generates some demand in the Richmond-Berea area. SCRA lease terminations are extremely common near Fort Campbell and Fort Knox. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Fort Campbell's deployment cycle creates regular waves of lease breaks. The 101st Airborne deploys frequently, and each deployment generates a wave of SCRA terminations from families who relocate during the deployment. Landlords in the Hopkinsville-Oak Grove area should treat SCRA processing as a core competency and should expect cyclical surges in military lease breaks tied to the deployment schedule. Kentucky has enacted protections for victims of domestic violence and dating violence that allow early lease termination. Under KRS 383.300, a tenant who is a victim of domestic violence, dating violence, sexual assault, or stalking can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid protective order, either temporary or emergency, or a copy of a police report or criminal complaint documenting the domestic violence, sexual assault, or stalking. The tenant must provide at least 30 days written notice before the termination date. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules. Kentucky's provision also addresses the locks. The tenant has the right to have the locks changed on the unit at the tenant's expense if the perpetrator had access to the premises. If the tenant terminates and vacates, the landlord must maintain the confidentiality of the tenant's documentation. Tenants in Kentucky may break a lease if the landlord fails to maintain habitable conditions. In Uvalde counties, the framework is more defined. Under KRS 383.595, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises fit and habitable, and maintain essential systems. If the landlord fails to act after receiving written notice, the tenant has remedies under KRS 383.625, including lease termination. The tenant must provide written notice identifying the deficiency and allow 14 days for the landlord to make repairs for non-emergency conditions. If the landlord fails to act, the tenant may terminate by providing written notice. In non-Uvalde counties, the habitability framework is less defined. Courts generally recognize an implied warranty of habitability, but the specific procedures, notice requirements, and remedies are less clearly established. Tenants in non-URLTA counties who need to terminate based on habitability should still provide written notice and document the conditions, but the legal path is less certain. Kentucky also recognizes constructive eviction in both URLTA and non-URLTA counties. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, failing to address dangerous conditions, make the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time. Kentucky's abandonment provisions differ between URLTA and non-URLTA counties. In URLTA counties, KRS 383.665 provides a framework for handling abandoned property and re-renting after abandonment. In non-URLTA counties, abandonment is governed by common law. The landlord should document evidence of abandonment before re-entering and re-renting. From a practical standpoint, Kentucky's rental market varies significantly across the state, from strong urban markets to some of the softest rural markets in the country. Louisville, the state's largest metro, has a diverse rental market. When a tenant breaks a lease in Louisville, re-rental times vary by neighborhood. The Highlands, Nulu, Germantown, and Clifton Crescent Hill have strong demand with re-rental typically within 2 to 4 weeks. St. Matthews and the eastern suburbs attract families and fill reasonably quickly. South Louisville and the West End have more affordable rents with more moderate demand. Louisville operates under URLTA, so the statutory mitigation duty and habitability framework apply. Louisville's Local Fairness Ordinance adds protections for sexual orientation and gender identity that affect screening of replacement tenants. Lexington, the state's second-largest city and home to the University of Kentucky, has a strong market. UK's massive enrollment drives student rental demand. Lease breaks timed to the academic calendar fill quickly. Lexington operates under URLTA and also has local source of income protections and non-discrimination provisions. Bowling Green has a moderate market driven by Western Kentucky University and the Corvette Assembly Plant. Bowling Green's growing refugee population adds diversity to the tenant pool. Northern Kentucky, Covington, Newport, Florence, functions as part of the Cincinnati Metro with steady demand. Fort Campbell's Hopkinsville-Oak Grove corridor is dominated by military rental demand. SCRA terminations are constant, and the deployment cycle creates predictable surges. Landlords in this area must have efficient make-ready and marketing processes to minimize vacancy between military tenants. Fort Knox's Radcliffe-Elizabethtown corridor has a similar military influence dynamic, though with less frequent deployment-driven surges than Fort Campbell. Eastern Kentucky, including communities in Pike County, Floyd County, Harlan County, and the broader Coalfield region, has some of the softest rental markets in the state. Population decline, the decline of the coal industry, and high poverty rates constrain demand. Most eastern Kentucky counties have not adopted URLTA, meaning the legal framework for broken leases is less defined. Re-rental in these communities can take months, and landlords must set realistic expectations. Frankfort, the state capital, has a small, stable market. Murray, Moorhead, and other college towns have student-influenced markets. One best practice for Kentucky landlords: determine immediately whether each of your properties is in a URLTA or non-URLTA county and build your lease and procedures accordingly. In URLTA counties, your lease should reference the statutory framework, and your early termination clause should be consistent with the Act's provisions. In non-URLTA counties, your lease needs to be more detailed because the statutory framework provides less guidance. The lease itself fills the gap. Another best practice: for landlords near Fort Campbell and Fort Knox who handle frequent military lease breaks, build SCRA terminations into your annual business projections. If a large percentage of your tenants are military with 2 to 3 year assignments, you can predict approximately how many SCRA terminations you'll process each year. Plan for this turnover, maintain efficient make-ready processes, and a continuous marketing pipeline. A third best practice: document your mitigation efforts thoroughly whenever a tenant breaks a lease. Whether you're in a URLTA or non-URLTA county, documentation of your re-rental efforts establishes the departing tenant's liability and proves you acted reasonably. Keep records of listing dates, advertising channels, inquiries, showings, and acceptance dates. In URLTA counties, Kentucky limits the security deposit to 1 month's rent. The deposit must be returned within 30 to 60 days of the tenant vacating. In non-URLTA counties, there is no statutory cap. The deposit is governed by the lease. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Kentucky breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.